Thank you very much. Can you hear me okay? It's great to see people. It really is. I was talking to a former auditor yesterday who I've known for over 20 years. I said, well, I'm going to be speaking to auditors tomorrow, and I don't know, I'm a little rusty. I haven't spoken to a group of county officials since January of 2020. And she said, oh, don't worry about it. It's like riding a bicycle. You're not going to forget how to do it. But I just want you all to know I appreciate the invitation. It's glad to be here with you. We've got some materials I want to go over with you today and just let you know that, you know, our group, and I've got Beck Hannaford with me here today, and I know a number of you work with Lori Seelan of our office as well as Addie Rooker. And these two women have been with our firm now for 10 and 20 years, and I would put them up against anybody as far as having knowledge in the workings of Indiana County government and how the human resources questions and issues all kind of fit together. This is not like running the private grocery store where everybody's, you know, working for dad. County government, HR, very tough job. Tough job being an auditor. You're on our mind. We think about questions that you're going to ask before you call. And for example, when I'm watching the news, and especially here recently with whether it's a tornado or some other weather emergency or this horrid collapse of the building down in Miami, to various other catastrophes that happen around our country, and see on the local news, we're getting a group of local city and county officials, and they're all heading off to head out and help these people during these disastrous events. And I'm thinking it's a very honorable thing to do. And my question is, how are they going to get paid? Who's paying these guys? Have they already figured this out before they leave town? Or is this something the auditor is going to get a call from in the middle of the afternoon saying, these guys are back and now we're supposed to pay them? How does that work? Do they take vacation time? How do we volunteer? Were they working for us when they were off on these assignments? And these are the kinds of questions that don't come up every day. But when they come up, we're often scrambling to try to find an answer in terms of what are we supposed to do and what's proper, and are we violating any of our regulations when we're paying people for work that they're not necessarily doing for our county. And I think, as most of you know, in your auditor's handbook, that the auditor is required to pay when there is a claim or a warrant that is based upon a policy that is being approved. So we can't pay for an extra holiday that somebody wants to take off unless it's been approved in our local handbook or personnel policy. So how do we do that when somebody just comes in and says you have to pay somebody because I let them off? And believe me, I know the auditors get it from every direction, from sheriffs to courts to prosecutors to everybody and their brother in the courthouse who's an elected official, and the auditor is always the one who's trying to be the boss of me and tell me what to do. And our counsel has always been, you're not the boss of the county, but you do have certain responsibilities that other office holders do not have. And that is to make sure that we're in compliance with a number of the federal and state wage and hour rules which come into play, and how they interplay and interact with a number of other policies that we have for paid leave and the like. So the job of being an auditor, and particularly a payroll, benefits, or HR person, is one, I think, one of the more difficult jobs in county government here in the state. And we get a regular question about, what if we just get a new HR person, that'll solve all of our problems, and we're going to go out and hire a new person, and they're going to come in, and they're going to be in charge of benefits, counseling, termination, recruitment, hiring. They're going to draft a new handbook, and they're going to write job descriptions for everybody, and they're going to be experts on health insurance. Holy moly. One person's going to do all this for you? Well, yeah, that's what HR is all about. The way it is down at my plant, that's the way it is in my business. This is the way it is on the outside. My advice to council, to commissioners, to attorneys is, look, it's much better, in my view, to have an HR person that has an understanding of the workings of county government. HR pieces can be learned much easier than I think how that all relates to trying to put together any kind of standardized policies or procedures that will work and that you can facilitate as an HR person, but you're not certainly able to boss anybody around. As opposed to city government, where you have a mayor who appoints all the department heads. They're not elected. And you have an HR person who's responsible for HR. So what the mayor says, what he or she says, pretty well goes. You have a chief executive officer that everybody has to follow. Not true, as you know, in county government, where you have all these elective offices with virtually a job of being a county auditor, of trying to herd cats when they're going in all kinds of different directions. And again, no one's the boss of me. We have received, over the last couple days, some calls from auditors and payroll people in some of the southern counties regarding some of the presentation materials that they've received. And I'm going to talk about some of these today, because I really believe that there's some information out there that is getting confused and what some of these auditors are being told. Now, this isn't something that has occurred in this regional meeting, but there's been some issues brought to our attention that have occurred in some of the others. So as I go through the materials here today, I'm going to point those out, and hopefully that they can be passed on from your group on to those who are in charge of the southern presentations. I'm going to mostly talk about today the Fair Labor Standards Act and the wage and hour rules and how they apply to Indiana county government. On page 3 of the handout that you have, we have noted some FLSA, some of the standard definitions that are a part of this wage and hour law that impacts how we treat our employees respective of compensation. And each county government, the jobs can be classified, should be classified under these FLSA definitions. The first being excluded. Jobs that are excluded include elected officials, and they include policy-making appointees, personal staff, and legal advisors. These employees are not covered by the Fair Labor Standards Act and are not eligible or entitled to receive overtime compensation or comp time off. Now I'm going to talk a little bit more about that definition detail in a minute. But this is really reserved to a very small number or group of county officials, particularly the elected officials, and possibly, and we can come back to that, chief or first deputies, depending upon the political nature and how those jobs are treated in your individual county. not all counties treat that chief or first deputy in the same way, which this is kind of another overarching point that I want to make, and that is sometimes when we get bogged down with a employee or an HR question, we tend to reach out to other people. What are they doing in Fulton County? What are they doing in Pulaski or another county? We call them. Well, we're doing it this way. Well, that's not the way we're doing it. Even though there may be differences in the way your policies are administered, it may not be a situation where one is right and the other one is wrong. It just may be something simply that the policies are different from one county to the next. And there are some individual nuances in terms of how policies are written, particularly as they relate to the FLSA and how you count hours worked, et cetera. Again, I'll mention that. I've mentioned that now, but I want to pick up on that here in a minute. The other classification, which you'll have a number of jobs within county government called exempt. These are jobs that have to meet a test under the FLSA. Excuse me, they're either professional, administrative jobs or executives that are exempt. That means they're not entitled to overtime or comp time for any work that they perform over the 40-hour threshold for the FLSA. But the last group is the non-exempt positions. These jobs can be hourly or they can be paid on a salaried basis. They are entitled to overtime or comp time under or time off under specific provisions of the FLSA and state wage and hour laws. Now, in the event that an elected official or department head requires a non-exempt employee to work overtime, such employees shall be granted overtime compensation in the form of monetary reimbursement at the rate of time and a half, the amount of time worked in excess of 40 hours in a work week, or they get crack cocaine of local government comp time. Okay? Why does he call it that? Because that's what it is. It's addictive, it's expensive, it's confusing, and it's hidden, and people save it up like part of their retirement fund. Well, I've been saving all these hours, all these years. I didn't tell my boss I was working through lunch. Blah, 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 blah. There's no record to show I did otherwise, and blah, 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 blah. Now you owe me for $10,000 in comp time. I'm getting ready to retire. What? What are you saying? No. Do you have a record to show that they didn't get comp time? Do you have a record to show that they did or it was paid out? Well, our records are all kind of, what they are, and everybody's doing their own thing, and every department gets to be their own boss, and they keep their own records, and I don't see anything, and I guess we're going to have to write them a check. Well, yeah, we were in a commissioner's meeting last week, and Joe, the truck driver, came in, and we paid his comp time out. Yeah, right, Joe, truck driver, non-exempt job. We owe Joe if he has any comp time hours. Highway superintendent walks in 10 minutes later, says, I'm retiring, I want my check too. Wait a minute. You're the highway superintendent, right? Yeah. You are the supervisor, yeah. You run the department, yes. You're in charge, yes. You're appointed by the commissioners, yes. Where do you get comp time? Well, I get it just like the other guys. No, you don't. No, you don't. You are exempt. You're not required to get overtime or comp time. Well, that's just the way we've always done it, which is always the answer. That's what they did when Fred was here. He got paid out, so you have to pay me too. Okay, here's the first example. Can you pay an exempt person overtime? Yes. Do you have to according to the FLSA? No. The FLSA sets a minimum, not a max. You can go over the max. The Fair Labor Standards Act sets a minimum wage. It's been $7.25 an hour since 2003. For 13 years, it has not changed. We have to pay the minimum wage. Can we pay more than the minimum wage? Certainly, but we have to pay the minimum wage. Same principle when it comes to, if you want to give comp time to the highway superintendent, you can. You can give the highway superintendent overtime. But you really, in order to do that, need a county policy that says that. You need something to support what you're doing, not just Fred or Joe or Bill coming in and saying, you owe me money because that's the way we've always done it. No. You need to have a policy. And we'll get the questions. The auditor calls, what are we supposed to do? Our first question is always, what's your policy say? Well, it says this, but nobody ever follows the damn thing. Okay, what are we actually doing? And then there's a description of what we're actually doing. Well, one of two things. I think, obviously, if we're going to continue to not follow the policy, then we need to correct the policy to make it cohesive with what it is we're doing. So they need to follow. What's a job description say? Is it an exempt job? It should say on the job description whether it's exempt or not exempt. Well, our job descriptions haven't been updated since 1914, and and nobody uses them anyway. And again, all these are the kind of the infrastructure of your ability to answer and process payroll. You've got to know whether or not the job is exempt or non-exempt, what the policy says. Now, most policies in defining FLSA exempt and non-exempt status will say exactly what's here. Most of them do. And I know we've prepared dozens of handbooks that are being used by Indiana county governments all over the state of Indiana. Most of them say this. If there is some nuance that is different, then it really needs to be reflected in the policy. So those are the basic definitions that we need to keep in mind when it comes to pay and being in compliance with the FLSA. The next page 4, there are now discussion on the exemptions for those jobs that are exempt. You can't make a job exempt just by looking at its title and say, hey, I think this one ought to be exempt. It's paid a salary, so we've always paid a salary, and that makes it exempt. Just paying a job a salary doesn't in itself make the job exempt. It has to meet one of these 3 duties tests in order to do that. So it's either going to be classified as an executive position, and the employees have to be paid, in each instance, executive, professional, and administrative. To be exempt, you have to be paid on a salary basis. You can't be paid hourly. Now, non-exempt positions, you can be paid hourly or you can be paid on a salary basis, either one. But exempt positions, in any of the 3 tests, you have to be paid on a salary basis. And in this case, effective January of 2020, this is the new salary threshold that executive positions are required. They have to make $684 per week or have an annual salary of $35,568. If they're not making $35,568, they don't qualify, even if they met the other tests. They have to meet the salary threshold in order to qualify as an exempt position. Up until that time, the amount was $23,660. And as you recall, we had a conference with the auditors on this back before 2016, when there was proposed regulations to take that salary threshold up to $46,000. When the Trump administration came in January, that was kiboshed. So that stopped. But since that time, since 2020, there were these new regulations issued by the Trump administration that raised the threshold, not to the 46, but up to the 35,568. So you have to, excuse me, you have to meet the salary test. Secondly, as an exempt, the primary duty must be managing the enterprise, managing a customarily recognized department, subdivision of the enterprise. They're directing the work of two or more people. They have the authority to hire and fire. Those are those people who are considered in the executive category. If they meet those tests and they're exempt, then they are not required under the FLSA to be paid overtime or comp time. A second test is professional, same salary threshold, and the employee must have advanced knowledge in the field of science or learning, and the employee's knowledge is required by prolonged specialized instruction. These are attorneys, the county engineer. These are the people who would fall within this professional exemption and would not be eligible under the FLSA for overtime. The last test is administrative, same salary test. The primary duty must be non-manual work directly related to the management or general business. The employee must exercise discretion and independent judgment in significant matters such as policy or finance. This sounds like a big, wide definition that a lot of jobs would fit. They're administrative, so they're exempt. Under the FLSA, this is a very narrow definition. There are very few jobs in county government that are going to meet that exemption. Most of the jobs that are exempt in county government are going to be executive or they're going to be professional. Okay, let's get back to the excluded. This is one, I don't even call it hardly a classification. It's just you're excluded. You're not classified exempt or non-exempt, you're excluded. The FLSA does not apply to you when it comes to the overtime rules at all. Back in that 2015-2016 period, a number of county officials, particularly county council members, holy moly, we're going to have to raise all the elected officials' salaries up to $46,000. My God, they're going to be making more than the governor. Not really, but it seemed like it to them. And there's no way we can do that. I mean, they'll be the highest paid people in the county, and da-da-da-da-da-da. So with a bit of legal research and an opinion letter, we went about conducting several workshops for county officials with the attorneys from Frost Brown that had done the research on this, that the term excluded applies to elected officials, meaning you're not required, it doesn't apply. So the salary requirement for exempt does not apply to elected officials. Even though we might like it to, it doesn't apply. And this is one of the areas that the Southern County auditors were told this week that that this exempt definition applied to elected officials. And in my view, it does not. And if you want, you can send me an email, and I'll send you a copy of the opinion letter that we had done at that time that outlines how that FLSA definition applies and how most counties from that point on started designating the elected officials excluded and their first or chief deputies as excluded as well if they're politically appointed. Now, you'll get people say, well, they're all politically appointed in my office. But when it really comes down to it, the statutes say the chief or first deputy is the political appointee. Now, some counties use that provision, and those employees serve in that position at will. They can be let go for any or no reason at all. They're not subject to all the steps of discipline that other employees have as far as any due process that may be a part of a union contract or may be a part of your handbook, where you need to go through progressive disciplinary steps in order to terminate an employee. If a job is a political appointee, it is highly advisable that they understand that when they're hired, as opposed to it being sprung on them when you or another person would become the elected official and you would lose your job, and all of a sudden they're out of a job. They need to understand that they serve in that capacity. It needs to be a part of the job description. They need to sign and date it as well as you sign and date it. So upon hiring, there's this clear understanding that that is the nature of this position, and it's different than the other jobs in the office. How many of you have political appointed chief deputies that fit what I just said as far as that definition? How many do not? I know that there are some counties that have specifically done away with that designation and have maintained that the rest of these employees are they're not exempt, they're non-exempt, and they're paid on an hourly or salary basis just like the other office workers. But some counties have still maintained that definition, and these people have been considered political appointees and therefore subject to the excluded definition as well. But that really needs to be a decision that is made county-wide. At least in my view, I don't think it should be one office that it is and the next one it isn't, that either all the first or chief deputies are treated the same way or not. The one exception may be the chief deputy sheriff. And that one's pretty clear. And most sheriff's departments, that's how it's set up. Although in a number of them, we've often run into, well, he's the chief deputy, but he gets overtime. What? Well, he's chief deputy, you know, he has to do certain things. He gets overtime like everybody else. He also gets about $30,000 more than the deputy. What's that extra salary for? Well, he is a chief. Well, you always run into certain people, they want to be chiefs until it's better to be an Indian. You know, when we want to get paid like the Indians, but we want the authority of being a chief, and we like that. So these are some of the little, crossfire hurricanes that you guys deal with from time to time when it comes to, having a question about how someone is to be paid. And there are some very specific rules about this, and oftentimes they're either unknown, or if they are known, they're ignored. And then when you try to enforce them, then the damn auditor's trying to tell us what to do. Yes, sir. Well, from a practical application perspective, the excluded clearly shows the distinction of the elected official. We all know that elected officials have to receive their salary. The elected official's salary is set by the council year to year. That one's pretty clear. The functional difference when we get down to like chief deputies is under the FLSA, it says you're excluded. And they are. Personal staff, attorneys, excluded. Now, then the question comes, functionally, well, we don't have to keep track of our time. We're just like elected officials. We can come and go as we please. Wrong. Nice try, but wrong. You have to follow the Indiana timekeeping requirements. You have to show that you work the full-time schedule in order to get your full-time pay. If you take off on Friday and want to be paid, you have to use one of our available paid leave times in order to get paid. So the functional difference is those chief deputies have to follow all the other policies, but for the fact that they are excluded like the elected official, but they don't get to come and go like the elected official. Make sense? Pardon? As far as the FLSA is concerned, that's about it. But the political nature, that's I think the bigger issue in terms of what's been the history in the county of how the job has been treated. And if it has been treated as a political appointee, then all the other things need to follow. Not just saying it was, but also having the documentation to support that in the way of a job description that employee received that says that they are a political appointee of the elected official, and they understand that coming in. Because the last thing you want to do is end up in a wrongful termination case because somebody can claim that, no, I've never been a political appointee. I do the same work as everybody else in this office, and I'm not a policymaker. The other kind of functional difference, too, that goes along with that chief deputy, if they are a political appointee, then it also needs to state in the job description that they perform the elected official's duties in the absence of the elected official. So they are next in charge in the event that the elected official is incapacitated, is on vacation, is whatever. They have full authority to operate as the elected official in their absence. So that's another key piece to make sure that you have documented if that's the way your county intends for it to work. Another piece of that, and I would highly recommend that this be a part of your salary ordinance as well. That there's a job title, there's the FLSA status, excluded, exempt, non-exempt, listed by every job. And I think really for ease in bookkeeping and having a clear understanding that if it's a non-exempt position, even though it's paid a salary, it wouldn't hurt to go ahead and put in there what the hourly rate is for that salary in the event that the person works overtime, and you have to calculate an overtime rate, which is time and a half that hourly rate. Okay? So if that's 35 hours a week, you need to take the annual salary, divide it, come up with an hourly rate. Question? Are jail matrons and commanders generally considered political appointment? I would say all matrons, yes. That's in the state, that's in statute. I'll come back to that one. That's another kind of unique animal. The jail commanders, I'd say that's about 50-50. Sometimes it is, sometimes it is not. Sometimes the jail may have a semi-merit process for getting promoted from CO or jailer to corporal, sergeant. They may have a process where you earn those promotions. Others, it's, who the sheriff likes. And we're getting rid of Fred, and you're going to be the man because I've had it with Fred. And hopefully that he retires, and this is all part of the county government way of doing things. And the management style we have around here is management by wishful thinking. Right? I just wish she would quit. God, I wish the assessor would hire away. Oh, I just wish the election were next week. I wish I had have fired her when I came into office. She's been a pain in the ass every day of my life, and why didn't you do it? I didn't want to upset her. I felt sorry. I knew her mother, her brother, her aunts, uncles, the commissioners related to her aunt, and God, Indiana is a family. Local government's a family business. Everybody knows everybody. So I didn't let her go. Now she's done this, and she's threatening me with that, and now she's on Facebook and social media, and I'm a bad person, and blah blah blah. If somebody does something so serious, you think that you ought to get rid of them. Start taking those steps, document it. Well, I didn't want to write anything down. What's the record show? There's no record, but I'm going to get rid of her. No, you're not. You're going to get sued. I didn't mean to go down that path, but it just, it's the way my little pea brain works. So the matron job is in statute. And part of, I guess it's folklore, I'd call it, or just sheriff's talk. Well, they have to be paid the same as a sheriff's deputy. No, they don't. Well, by God, that's the way they do it next door. And that guy's, he's been the head of the Sheriff's Association. He knows everything. Nope. Now, there was a time in the law that says that the matron shall be paid the same as a road deputy. And then that changed. There was a whole court case that involved, I believe, was LaPorte County. That changed. So that job doesn't require a person to go through the academy like a police officer. All kinds of differences. It's just a political appointee. It started out as Aunt B's job. Remember? Aunt B was the matron for Andy and Barney. She took care of Otis. That was back when the sheriffs, lived at the jail. They took care of Daphne and whoever else would happen to get arrested once in a while. Women didn't get arrested back in Mayberry. It was only, except that one gal that set Barney up and to talk all the bad stuff about Andy, and spent too much time in the front of the TV the last 18 months. Safer Andy Griffith than CNN, Fox, or CSNBC, and I can't take any of those anymore. It's just like, no, parental controls off. But that job evolved from those times when the sheriff's wife took care of the food, the commissary. It's just outdated. In a lot of counties, it's gone away. Others, it's still there. I think where it still exists, it is a political appointee. You can put anybody in there you want. So actually, sheriffs have used that job in a number of different ways. I mean, oftentimes it's an administrative assistant, office manager in the office. It's been used as, I know one sheriff's wife was an RN, so she took care of much of the medical side. So that job's been used in a number of different ways, but it does not have to be paid the same equivalent salary as a road deputy who's a merit officer in the police department. It can be classified and paid similar to what you would pay other jobs that have the same requirements as far as knowledge, skills, and et cetera. So it should be comparable in pay to others that are similar to it, the duties and responsibilities. Okay. Let's jump into this quiz on page 5. Number 1, you can just go ahead and mark them as we go, but put down what you think the answer is. We'll talk about it here in a little bit, each one. Longevity pay or any other extra pay, such as performance bonuses, on-call, or shift differentials, does not need to be added to the straight time hourly rate when calculating overtime. True or false? Put down your answer. Number 2, the FLSA requires non-exempt employees to be paid at time and a half for all hours worked over 8 hours in a work day. True or false? Now on this one, I'll stop. How many of you said true? How many said false? This is false. Who can tell me why it's false? It's after 40 hours in a work week. It's not after 8 hours in a work day. This is something that you'll find in a union contract. It'll be one of the first things that unions negotiate. We're going to pay after 8 in a day, not 40 in a week. So if somebody's off those other days, then that's it doesn't matter. If they're off and not working, you have to actually work 40 hours in order to be eligible for overtime under the FLSA. So this one's false. And it's 40 hours in a 7-day work week. You define when the work week stops and when it ends. Number 3, county employees are restricted from working in more than one job for the county, same employer. True, false? How many say true? Nobody. How many say false? Who wants to tell me why is it false? Because our county has people do that. It is false. You can. Now, certain things come into play when this happens, okay? If it's a non-exempt employee, you must combine their time from both jobs to calculate overtime. Whoa. So somebody works 40 hours in one department and 10 hours in another department, you're staring at 10 hours of overtime. Ooh, who pays for it? Ooh, there's another, all kinds of good questions. I've always felt, and most, I think, counties do, whoever generates the overtime, that's the department that pays for it. And there have been instances where employees were working in another county office or department that the original or their central job department head didn't even know about it. This was the genesis of a lawsuit in one county where jailers were working a full shift, and then on weekends they were going to community corrections in a facility and working as security people over there, and they weren't counting their overtime. And knock on the door, here comes the Department of Labor, the federal investigator comes in, oh boy, got a problem. You're not paying them overtime. Well, we don't have to. That's Sheriff's Department over there. Community Corrections, that's under the courts. In a different county? No, we're still the same county. You're the county. The county is the employer. Not the Sheriff's Department, not Community Corrections, it's the county. The county is the employer. So, the feds look at a single employer. So it doesn't matter which department or office you're working. If those hours go over 40, then the person is owed overtime at time and a half, or, God, get into the comp time thing. I don't know how in the world, I wouldn't even consider comp time in a multiple job situation. It'd really be tough. Number 4, salaried employees are not entitled to overtime pay and comp time for work over 40 in a work week. True or false? Why false? Depends on classification, meaning? Exactly. Salaried exempt employees are not entitled to overtime. Salaried non-exempt are. Well, I've always thought, my husband's shop, they talk about salary, and everybody's salary, and they don't pay any overtime. So I don't know why, we're even talking about this. You can be paid on a salary basis in the auditor's office as a deputy in the auditor's office or the recorder's office or any other office. You can be paid a salary and be paid on you're not being paid hourly. You get the regular salary. Divided up by the number of payrolls you have, taking the annual salary. You're paid on a salary basis. But if you work over 40, we have to derive a straight time rate to figure out an overtime rate to pay you for that time and a half after 40 that we owe you. What happens to the hours between 35 and 40? What happens to those hours? You just work them for free? No. Those are straight time hours up to 40. You don't have to pay time and a half between 35 and 40, just straight time up there. I'll get you real confused. There's 2 flavors of comp time. Oh my God. 2? Yes. There is FLSA comp time, which I'd call premium comp time. that is after 40 at time and a half. That's the federal law. Now, you can have Fulton County comp time, non-FLSA comp time, if you're a 35-hour work week, hour for hour of comp time up to 40. You better keep those in two separate buckets. The premium comp time is what's regulated by the government. The government doesn't care about your hour for hour comp time. So the thresholds for comp time are solely based on what the federal requirement is. Number 5. Fair Labor Standards Act requires that part-time employees receive holiday pay for all holidays in which full-time employees receive holiday pay. How many say true? How many say false? Okay, you guys need to call your southern neighbors and tell them how smart you are. Or that you got a better speaker or whatever. But I'm telling you, this is what they were told, that part-time employees had to be paid holiday pay. I'm thinking, what in the world? You know, most all policies show some distinction between full-time benefits and part-time. And usually part-time get very few, if any, benefits. Holiday pay is a benefit. You know what? The federal government does not care about your holidays. There's no requirement by the FLSA to pay anything beyond the hours that people actually work. There's no rule that you have to have the 4th of July off. None. Most of us do. We're all very patriotic. We don't want to not have the 4th of July off or any of the other 1,400 holidays that we get, which is kind of a selling point for working in public sector. People saying we're having trouble finding, workers. So well, what's the benefit side look like? What's the health insurance look like? Even compared to the private sector, what's it look like here at the county? How many paid holidays do you get in your private sector job? 3, 4, 5. We get 15, including election days. What? Yeah, didn't happen this year. We still get some time off. Whatever. But there is no requirement to pay a part-time employee holidays. Can you? Yes. Do some counties do it? I've seen a policy or two where they may, if you were normally required to work that holiday, you might get paid for half of it or something. But those are all policies that you would need to have that would authorize the auditor to pay that. So Joe, you just can't walk in and say, well, I want my part-time employee to be paid for 4th of July. No, we can't do that. Policy doesn't allow it. But is someone in the other conference were telling people that this is something they had to do. And the phone rings, and I'm going, what the hell's going on? Number 6, employees have sole discretion in deciding when to take comp time off. True or false? False. This is one of the smartest groups of auditors I've ever seen. That, or you may have seen this question at an earlier conference. This is one of the few times that our U.S. Supreme Court ruled in a unanimous decision that a sheriff in Texas could schedule off comp time. The guys came in one day and said, we're all going fishing. Not all of you. Yeah, it's our comp time. We decide when we take it. No, you don't. That went to the Supreme Court. A lot of energy, time, lawsuits, lawyers. People made money off of that question, but the Supreme Court ruled that the employers have the discretion in scheduling it off. Can you not ever not schedule it off? No. You have to do it within a reasonable time, when you can, as long as it doesn't affect your operations. But if you don't get it scheduled off, it doesn't evaporate. You're going to pay it off. You can pay it off anytime, but you'd have to pay it at retirement, and comp time you pay off at retirement is really accrued in value from the time it may have been earned 10 years earlier, because you have to pay it off at the current rate of pay, not when it was earned. So another piece of that crack cocaine business. Number 7, under the FLSA, non-exempt, non-public safety employees may accrue 240 hours of comp time before monetary payment is required. How many say true? Come on, how many said true? This is true. 240. That's what the Fed has as a max. Do we want to have people with 240 hours? No, probably not. Do most counties, if they have comp time, do they set a lower threshold? Yes. Advisable, 40, 80. You don't have to go to the 240. You can set it. You don't have to have comp time at all. But 240 is the absolute maximum that you can have on the books for any one person. After that, they have to be paid in money. Now, for public service, public safety employees, such as sheriff's deputies, such as correction officers, they can go up to 480 hours. Do you want them to have that? That's your call, but that is their threshold before it has to be paid off. Does that apply to dispatchers? No, it does not apply to dispatchers. Public safety in my mind, but not under the FLSA when it comes to the overtime rules. Number 8, employees may choose to work additional hours or weekends for overtime compensation without receiving prior authorization. True or false? Should be false. But if they do, even without authorization, and you have permitted them to do it, you're going to have to pay them. So most of these policies will have some provision that requires prior authorization before doing it. And if it's not in your policy, it needs to be in your policy. Yes. You have, if they work, you have to pay them, even if they. But it's your responsibility to stop them from working. If they go ahead and work anyway, and turn in the time, then it's time to get out the little documentation and said, you're beginning this process of saying sayonara with this office, and I'm not putting up with this anymore. Number 9. The FLSA requires employers to maintain payroll records containing employee names, work hours, worked each day and work week, wages paid, deductions from wages, straight time wages, and overtime pay. The answer is yes. Those are all things that the FLSA does require in terms of record keeping. If it's not done in the auditor's office, it certainly needs to be done somewhere. And this is not, the FLSA is not a suggestion. It's a law. And too often people blow this stuff off, and we end up in some kind of a back wage claim, and all of a sudden we're paying out all kinds of money because we weren't documenting, we weren't following what the policies required, and the employees sometimes are well versed, better versed sometimes than department heads on what's in those policies and how it applies to them. number 10, under the FLSA, only actual hours worked up to 40 in a work week are used to determine when the FLSA overtime time and a half is owed for time worked over the 40 hours. How many say true? This one's true. Actual hours worked. So if I'm off on a sick day, I am off on vacation, I am off on bereavement, I'm off on vacation, I'm not actually working. So unless the policy says something to the contrary, I'm not owed time and a half. If I work 10 hours on Monday and then have the rest of the week off, I might be paid for paid leave, but those 2 hours are not at time and a half. I didn't actually go over the 40-hour threshold of actual work. Again, this is where, well, Joe from county over here said they do. We don't. Some counties will have policies intentionally that will put in the policy that a paid holiday counts as a hour's work for the purposes of calculating overtime. Now, how did that policy come to be? Right, the highway guy. Well, Dan, we're coming back and doing a snowstorm, and we're not going to get paid time. We're not going to work. Well, by golly. Who's in charge of this department? Well, that's a whole different. No, it's just those hours aren't going to be a time and a half. So oftentimes, the commissioners, well, that's not right. It needs to be a time and a half. So the policy will change, and they will carve out that holidays count as actual hours worked. Nothing else does. But that usually leads to another. Well, it's not fair just to have a holiday. How about bereavement? I didn't, my mom didn't die on purpose. I had to go to the funeral. That ought to count. Yeah, by golly, I felt for old Sue, and it just everything gets to be personal, and then we get a new policy. Some of these policies in your handbook have faces next to them of the photo of the person who originated the policy. That was Harold's policy, remember? Yeah, he had 500 hours of comp time. I remember that. That was the funniest damn thing. Paid him off. All right, I saved number 1, longevity pay. This came up 2 weeks ago, one of the auditors, and sent me to work, looking. I know it's somewhere. Next page, we show fact sheet from the FLSA. Bonuses under the FLSA. Bonuses, attendance bonus, basically. Longevity, you get it according to a schedule. It's not discretionary. You've published it. Everybody knows you're going to get it. Council will argue, well, we vote on it every year. When's the last time you voted no? Well, no, they've always got it, but, they need to come to us and ask, and then we're real nice and say, yeah, we're doing you a favor. We're going to vote for it again. These non-discretionary bonuses have to count in the calculation for overtime. Well, then maybe we just won't have longevity. It's not that big of a deal, really. Let's, for example, say that a person's making $35,000 in base salary. And let's just say they get $2,000 in longevity for the whole year. I mean, it's paid out in a lump sum sometime in the year. So whenever that person, and only when that person works 41 hours, would you even worry about it. But you would need to add the 35, the 2, you got 37, you divide that out, and you get an hourly rate, and then that's time and a half. So it's not just the hourly rate of the 35,000, it's just that additional 2,000 that you've added to it. On a 40-hour work week, that's like $17.78 an hour. Straight time, it's 26.64 an hour for the overtime rate. It's not that big of a deal. It's about $1. It's about $1 difference. But this is one of those technical violations that if you're ever investigated, the FLSA or Labor Department guy, they will zero in on this. Do you pay longevity? Yeah. Do you include it in your pay? No. Oh, you don't? So the county that I was talking about with the correction officers and the jailers, I think we'll have the rest of the county officials reconstruct their time records for the last 2 years. Holy moly. Who for? Well, for all your employees. The ones that are here now? No, the ones that were here during the last 2 years. The ones that have left too? Oh yeah, you may owe them some money. So now you're into this whole long, drawn-out audit of your records. So you want to make sure you're doing it properly in the first place. And at the end of the day, the county that had this horrific investigation lasted for 2 years. I mean, they ended up paying about $500,000 in back pay, attorney's fees, and then they promised to God and swore in Bibles and everything that they would never violate the policies again. Well, I checked it, huh? The time period back is 2 years from the date of a complaint, or it can be 3 years if it's willful. Willful. I came in and told you you owe me overtime pay, and you said, go fly a kite. That's willful. If I'm found to be in violation, they can go back 3. They will go back. They'll go back 2. So if we have a violation and we know about it, my advice is always fix it. Get it fixed. Don't let it continue to grow. Get it fixed. Do the calculation. You owe somebody, pay them, and get it out of your hair. And that includes people who've been working in more than one job. A dispatcher worked in jail. Whoa. This went on for a long time in one county. There was about 6 people affected. Figure it out. Pay them. That's what they did. But this is the support of what I was saying in terms of that longevity statement, that it has to be included. So people said, well, where does it say that? It says it right in the FLSA. And this is how it's interpreted. The FLSA record keeping is also on page 7, and we've included the Indiana record requirements. So when you get that exempt or excluded employee saying, we don't have to keep track of hours, we're exempt, we're excluded. No, in order to be paid for Friday, if you're not working, you have to show that you either worked or you're using one of our paid leave times. Anybody have a question? Testimonial? Hungry for lunch? Nope. Okay, thank you.